Bless you. Court calls the case, People versus Samira Smith.
Right out of the gate, this hearing already feels heavy. You can hear how quickly the courtroom moves from routine procedure into something far more serious. Judge Simpson wastes absolutely no time getting the case on the record, and from this point forward, every single legal choice matters. What makes moments like this so important is that a lot of viewers hear terms like preliminary examination, bound over, or stand mute and assume these are small procedural details. They are not. These are major strategic checkpoints that can completely shape how a criminal case unfolds moving forward. And pay attention to the energy in this courtroom because it matters. Defense attorneys are already signaling negotiation attempts. Prosecutors are holding leverage, and the judge is carefully tracking compliance, risk, and credibility. That's the hidden tension in hearings like this. Sometimes the loudest drama isn't yelling, it's what people are trying not to say out loud. This case also immediately introduces emotional stakes involving probation issues, family hardship, and future consequences that could spiral very fast depending on how the court reacts. And trust me, later in this hearing, Judge Simpson is going to make it crystal clear that credibility inside a courtroom is everything. One bad answer can change the entire tone instantly.
Senior Assistant Public Defender representing Ms. Smith. Ms. Smith, would you please state your name?
Thank you.
Your Honor, at this time, Ms. Smith will be waiving the preliminary examination. She is aware that there are no offers, but we are continuing to discuss matters with the prosecutor and are also hoping to be able to work out a COTS agreement. Is that correct, Neil?
All right. You understand that the preliminary examination is a proceeding where the people would have to show by probable cause that the offense was committed and that you committed it. You understand that, ma'am? And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Okay.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over to circuit court on the single Ms. Gaines.
Your Honor, we acknowledge receipt of the information, waive its reading on the record. At this time, my client wishes to stand mute and have the court enter a not guilty plea.
Defendant having waived reading standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
August 12th at 1:30 before Judge Slay Monday.
August 12th, 2024, 1:30, Slay Monday.
Your Honor, may we address bond, please?
Right.
Your Honor, my client is a young woman. She's 20, just barely, just soon to be 21 in a few weeks. She has had a very challenging past few months. She has been, she recently had a son who is about a year old now. Her mother died unexpectedly in April of this year. And she has just had a very hard time financially, emotionally.
Now the defense is doing something extremely important here, humanizing the defendant before the court rules on bond. This is not random emotional storytelling. Attorneys often use hardship, family instability, financial stress, and childcare responsibilities to argue that a defendant deserves a lower bond or a personal recognizance release. The goal is simple: convince Judge Simpson that this is a struggling person, not a flight risk or ongoing danger. But here's the problem: sympathy alone rarely overrides probation concerns, and once the court hears there are already Oakland County issues hanging over this defendant, the atmosphere changes immediately. Judges take probation violations seriously because they suggest prior court supervision may not have worked. That becomes a credibility issue fast. Notice how the defense keeps emphasizing the one-year-old child, the grandmother, Section 8 housing, and financial instability. They're building a narrative around stability and survival. They want the court thinking, if she stays locked up too long, multiple lives are affected. But courtroom viewers know something else is happening here too. The judge is silently calculating risk versus compassion, and sometimes those two things collide hard.
And it's manifested in many different ways, which includes having had some prior trouble in Oakland County before this, for which she is on probation. And we do believe that there are holds for Oakland County. We are asking, however, that the court consider giving her a bond that she could post. We're asking if the court will not consider a personal recognizance bond a $1,000 cash or surety bond, so that she can get to Oakland County and begin to resolve those matters as well. My client, as I said, has a 1-year-old son. At this time, her 85-year-old grandmother and her older sister are looking after him. But she does have Section 8, which is of great value to her and her son. And she would like to be able to keep Section 8, and an extensive amount of incarceration will impact her ability to do that.
Ms. Gaines, is she on probation on 9 offenses out of Oakland County?
I think it's 2 cases with and between them, the 9 counts. So yes, I'm saying correct. I just don't know the number of counts. I knew the number of cases.
Okay.
She does have family support. Her cousin, David John, is here in the courtroom. He indicated that her grandmother is trying to get here, and she would return to her address in Detroit, where she does have the voucher and would be able to take care of her son upon completion of the Oakland County matters, she hopes.
Did she violate on the Oakland County matters?
I do believe that there is a violation of probation, holds out of Oakland County as a result of this matter.
And there it is, the moment the bond argument basically collapses. The second probation violations officially enter the discussion. Judge Simpson's posture shifts from consideration to concern. In courtroom culture, prior supervision problems can completely destroy momentum for a reduced bond request because the court starts asking a different question. Why should I trust compliance this time? The defense tried hard to frame this as a young woman overwhelmed by grief, financial pressure, and instability, but judges also have to evaluate public accountability and court reliability. Once probation violations are attached to the case, the argument for leniency becomes much harder to sustain. What's especially telling is how quickly Judge Simpson moves once he feels he has enough information. That's something viewers should always watch carefully. Experienced judges often signal decisions before they officially announce them: shorter responses, fewer follow-up questions, tighter control of the hearing. By this point, you can already sense where this is heading.
I don't necessarily need anything from the people unless you want to say something. Motion for bond reduction is denied. Bond will continue.
Thank you.
A plea agreement, and that form should have been tendered to Your Honor and to defense counsel.
I do have it. The form indicates that the defendant will be pleading guilty to child abuse 4th degree, punishable by up to 1 year, up to 5 years probation. And upon a successful plea to that charge, count 1 would be dismissed. There is no other agreement.
That is correct, Your Honor. I'll think it.
John Matthew Carlson.
Has he signed an advice or rights form, counsel?
Not to my knowledge, Your Honor. I can have him sign one right now.
Have the defendant sworn, please.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Sean Matthew Carlson.
Sir, it is this court's understanding that you're going to plead guilty to the charge of child abuse 4th degree. That is a misdemeanor punishable by up to 1 year incarceration and up to 5 years probation. Is there a maximum fine on that? Mr.
I
Reisman?
don't believe so. 1 year or probation for up to 5
years, no maximum.
1 year
All right.
jail or probation up to 5 years, no monetary.
Gotcha. All right, you understand that, sir?
Yes, sir.
All right. Now, you also understand that pleading guilty in this case, that I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court.
Yes, Your Honor.
All right, understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You had signed an advice of rights form today, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You'll see it on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes, Your Honor.
Now we're entering an entirely different kind of courtroom tension, plea hearing tension. And this is where things can become extremely dangerous for defendants if they are not completely truthful and consistent. Judge Simpson is walking through the standard guilty plea procedure step by step, making sure the defendant understands every constitutional right being waived. Trial rights, appeal rights, sentencing, exposure, all of it. But the real issue isn't the paperwork. The real issue is factual consistency. Courts require what's called a factual basis for a plea. That means the defendant's own statements must actually support the crime being admitted to. If the story changes, minimizes conduct, or conflicts with evidence, alarms go off immediately. And pay attention because that's exactly where this hearing is heading. The defendant admits striking the child, but the details are about to become critically important. In child abuse cases especially, the difference between arm, face, accident, or excessive discipline can dramatically affect how the court views honesty, accountability, and danger. This is the kind of moment where one sentence can derail an entire plea agreement in real time.
February 20th, 2024, at the location of 3137 Homestead Commons, Apartment 5, Ann Arbor City, Washtenaw County, State of Michigan. Did you have care or custody of a minor child?
Yes, Your Honor.
And what did you do with reference to that child?
I hit him in the arm with a closed fist.
All right. How old was the child?
10 years old at the time.
All right. And in doing so, you were doing something in excess of discipline?
Yes, Your Honor.
And that you would admit, cause physical harm to that child?
Yes, Your Honor.
I'm sorry, I didn't hear the initial factual basis for the plea.
Which part?
What did he say he did to the child?
He said he hit the child with a closed fist in the arm.
Okay, so if I could just read and make sure that this is correct for the record, the police report, Sean approached Anthony, the minor child, and punched him with a closed fist in his face, causing his head to snap against the wall. Is that correct, sir? Did that happen?
That's not what happened.
Okay, there's a big difference between the arm and the face.
Yes, Your Honor, I do believe it's a sufficient factual basis, however.
Was his nose bleeding when the police arrived, sir?
No.
Your Honor, would the court accept a no contest plea?
I don't know if the deal was continued upon him pleading guilty, but obviously we have two very, very different versions of what happened. I mean, either the child got hit in the face or the arm, and either the child was bleeding or he wasn't.
Judge Simpson just exposed the exact reason judges become frustrated during plea hearings. Conflicting facts destroy confidence in the process. The court is trying to establish a reliable record, but the defendant's version suddenly clashes with the police report in a major way, and this is not some tiny technical discrepancy. We're talking about whether a child was struck in the arm versus punched in the face hard enough for injury concerns to appear in the report. That is a massive difference. You can actually hear the courtroom momentum stop cold. The judge immediately recognizes the contradiction and refuses to simply glide past it for convenience. That's important. A plea hearing is not supposed to become a guessing game. Courts need clarity before accepting responsibility admissions. What makes this even more dramatic is that the defense now pivots toward requesting a no contest plea instead. That move often happens when factual disputes, memory concerns, or civil liability issues create risk for the defendant. In other words, they are trying to stabilize a plea deal that is starting to wobble badly.
do this. Why don't I pass the matter? Counsel, why don't you talk to your client?
Yes, Your Honor.
And then I'll call you guys back up. And let's see what we can do.
Thank you, Your Honor.
Thank you.
Advisor again on behalf of the people, Your Honor.
Assistant Public Defender Davy Lieb on behalf of Mr. Carlson, who stands to my right. Mr. Carlson, can you state your name, sir?
Sean Matthew Carlson.
Thank you for the court's patience, Your Honor. I have had additional discussions with Mr. Carlson as well as the conversation with the prosecutor. At this time, Mr. Carlson would like to enter a no contest plea.
Do I have? Oh,
I don't have an objection to that, Your Honor, and I have marked the police report as People's Exhibit 1, Ann Arbor Police Department, 24-7818, and marked the injury to the child and the relationship and the statement from the report. And ask that that be admitted on the basis of.
any objection, counsel, to the court reviewing this report?
No objection, Your Honor.
That being 24-7818 of the Ann Arbor Police Department. Sir, you and the understanding is you wish to plead no contest?
Yes, Your Honor.
The basis for the no contest plea, counsel?
Lack of memory as well as potential civil liability.
All right. You understand that all the rights that I explained to you apply to a no contest plea?
Yes, Your Honor.
And everything is exactly the same. It's just that you are pleading no contest to the charge. You understand that?
Yes, Your Honor.
So to that charge, how do you plead?
No contest.
Review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
So after all that tension, the court ultimately accepts the no contest plea. But notice something very important here. Acceptance does not mean the judge suddenly became comfortable with everything he heard earlier. It simply means the legal threshold for proceeding was satisfied through the report and supporting record. That distinction matters a lot. A no contest plea is strategically different from a straight guilty plea. The defendant is not openly admitting every allegation in the same direct way, but the court can still treat the plea as a conviction for sentencing purposes. In emotionally charged cases involving alleged child abuse, defendants sometimes prefer this route because it limits direct admissions while still resolving the criminal matter. Still, Judge Simpson clearly has unresolved concerns. You can hear it in the pacing, the questioning, and the continued focus on the child's safety and living situation. Judges often keep evaluating behavior even after a plea is accepted because sentencing and supervision decisions may still be ahead.
Yes, the people are saying.
Defense is likewise satisfied, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing in this matter will be
August 30th at 9:30 before Judge Terry.
August 30th, 2004, 9:30 before Judge Perry.
Your Honor, you could just check on the form that it was a no contest plea, and the one other additional part that I believe was discussed between parties is there will not be a delayed or a deferred.
Is that correct?
That was discussed, Your Honor.
Well, was it agreed to?
In terms of my discussion with Ms. Willenbring, I believe I just asked if she would be offering one. I don't know that we necessarily agreed that we would not be seeking one. However, that may have been a discussion with the previous attorney.
What?
That may have been a discussion with the previous attorney on the case.
So just maybe a miscommunication. No, we're not offering one means that the reduction happens and we're not offering it and he's not seeking it.
And that is correct.
So that is correct.
Yes, Your Honor.
He's not going to be seeking it delayed or deferred.
That is correct.
You understand that, sir?
Yes, sir.
Thank you.
He's not around this child currently, is he? I mean, probably the worst thing is he told me something. I'm looking at the police report. He's telling me he hit him in the arm. There's a clear injury to his face. And
I know that CPS is involved. I would like to think that they remained involved, although I don't know that for certain.
He did complete a reunification process through CPS, Your Honor.
This is the strongest emotional reaction we've heard from Judge Simpson the entire hearing, and it reveals exactly what is bothering him: accountability. The judge is openly signaling that he does not believe the minimized version of events matches the visible injuries described in the police report. That's a serious credibility problem. And notice how quickly the focus shifts from legal procedure to child safety. Once CPS involvement enters the conversation, the court is no longer just evaluating a criminal charge, it's evaluating whether the child remains protected moving forward. That's why Judge Simpson keeps pressing on reunification, parenting classes, supervision, and the defendant's current access to the child. What really stands out is the judge's frustration with what appears to be minimization. Courts can sometimes tolerate emotional explanations or imperfect memory, but judges become extremely concerned when defendants appear unwilling to fully acknowledge obvious harm, especially in cases involving children. This is also a reminder that judges constantly assess future risk, not just past conduct. Even after a plea agreement, the court still wants reassurance that the underlying behavior will not repeat itself. And right now, Judge Simpson clearly is not fully reassured. Do you think the parenting classes and CPS process were enough here, or do Judge Simpson's concerns still feel justified?
And so what's the status currently?
The child is residing with Mr. Carlson. Under the guidance of Child Protective Services.
What's that mean?
He completed a reunification process. My understanding is that they maintain some involvement.
Okay, so what is that involvement?
Just recently, my CPS social worker just closed the case out just early July. Since then, I've also been going through a lot of parenting classes, and I'm going through some other things through affiliates of with protective services, with like orchards and other.
Are you taking parenting classes now?
I completed mine. It was a 10-week course.
Pardon?
It was a 10-week course.
And so you're doing, there is nothing, the child is just with you.
Yes. And protective services thought it was still okay for him to be with me.
I got some serious concerns with a man that can't realize that he didn't hit a child in the arm, but hit him in the face, and coming before a court and telling me that. So you're lucky to be leaving today. You may leave.
Thank you.
That final statement from Judge Simpson says everything. Even though the defendant is physically leaving the courtroom today, the judge makes it crystal clear that he remains deeply troubled by the lack of acknowledgement surrounding the child's injuries. And in many ways, that final warning becomes the emotional conclusion of this entire hearing. Across both matters in this courtroom session, we saw two very different legal situations connected by one major theme: credibility. In the first case, bond arguments collided with probation concerns and prior legal trouble. In the second, a plea hearing nearly unraveled because the defendant's version of events conflicted with the police report and injury descriptions. Judge Simpson consistently focused on accountability, compliance, and public safety. Whether discussing probation violations, child welfare, or plea accuracy, the court repeatedly emphasized that facts matter and inconsistent statements can seriously damage trust inside a courtroom. The most powerful takeaway here is that judges are constantly evaluating more than just charges. They evaluate honesty, responsibility, risk, and whether someone truly understands the seriousness of their actions. And by the end of this hearing, Judge Simpson clearly wanted the defendant to understand just how close this situation came to becoming even worse. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.